Hi, everyone. Carl Sandbeck here. Thanks for joining us tonight. Sorry about that. Wanted to talk tonight about something different than what I've been covering about the Adelson case with the Florida Adelsons. That want to talk tonight about the Karen Reed case, some of the overall big picture issues that I see as a trial attorney regarding this issue about the mistrial and the immediate announcement of the district attorney that they're going to retry the case. And I have some thoughts and observations about this case. I've not followed this case that much detail. I'm not here to talk about the intricate details of the case and whether she's guilty or not, but I'm here to talk about observations because you may think someone's totally guilty as a juror, but you just don't have the evidence to back it up in order to feel confident with the conviction. All jury instructions across the United States, state and federal court, all have indications of what it takes to convict beyond reasonable doubt. A lot of them are very much the same, and it has to do with hesitancy to act with regard to your most important personal affairs. And so, for example, when I'm a defense attorney, I bring up issues like buying a house, who you marry, the most important critical issues of your life. Would you have any hesitancy to act on that with a degree of evidence that's been presented by the prosecution? So I'm totally looking at this from the level of proof standpoint and not whether she's absolutely guilty or not, because you could actually all agree, and the juror, maybe the 12 jurors that we heard about yesterday, maybe all 12 thought she is guilty, but the proof just wasn't there. So that's the way our jurisprudence system works here in the United States, is that you have to prove it, you just can't think it. So that's something I very much distinguish as a defense attorney if I think there's are indicators of guilt for my client. And certainly some of you here have made comments I see beforehand indicating she's 100% guilty and all that kind of stuff. But it's beyond that. Our justice system requires proof beyond reasonable doubt. So the proof has to have a good foundational bedrock of credibility and have that solid structure, which you can put the weight of something as serious as a murder to conviction on somebody like that. So that's what I'm here to talk about, is more the big picture level, the drone level, if you will, approach of how I looked at this case. And when I saw that was announced, without even knowing how the jurors' viewpoint of the case was, that they announced it right away, I thought that was a rush to judgment, and I thought it was misguided by the district attorney to do it that fast. So one of the similarities, because I've been covering almost exclusively now, as you've seen for the last year and a half, the Adelsons and their murder of Professor Dan Markell there in Tallahassee, Florida. I've talked about numerous times about how people in the general public have no idea how political the criminal law arena is. And by political, I also mean corrupt, right? So those two things a lot of times go hand in hand. And so if you compare and contrast it to, like in the Florida case with the Florida Adelsons, they had political clout that was running interference for them that kept them from being prosecuted for up to 9 years, and some of them still haven't been prosecuted. So that basically hamstrung justice by dragging it out, not going after those guilty parties. What we have up here, by contrast, any of you that have been following this case, you can see some of the politics that have infected this case. And some of the politics are also reflective of the lack of serious regard for the rights of John O'Keefe. Me having served many years at various times as a prosecutor, as a chief prosecutor, and as a supervisory uh, prosecutor above those levels, my position is that we have to have everything above board. Everything has to be professional. Everything has to be dress right, dress. Say in the military, you don't cut corners to deprive people of their rights, and you don't hide the ball on things, and you don't have conversations off the record and whatnot to gum up the case and look like you have some other agenda. If you look at, for example, what happened with this investigator Proctor, that was such an abysmal thing that he did. The way he talked about Karen in his text messages with other troopers is absolutely something that he showed zero regard for the rights of the victims, in this case, John O'Keefe and his family. So to me, I was very disgusted with that. And as a prosecutor, I can say that that's the kind of thing you could maybe get an acquittal on. So even though you got otherwise solid evidence, some jurors could be totally ticked off the way women are disregarded and maligned with such crude despicable terms that Proctor used, that you're really risking the entire case being turned upside down of a, let's say, an otherwise guilty party based on the misconduct of the law enforcement. So that is very much something that I find offensive, as should all of us, right? So ultimately, the um, the thing with Proctor, also what bothered me was the state waited until after the conviction to discipline him, and they said we only found out about his behavior, his despicable behavior during the trial. Well, where was District Attorney Morrissey in this matter, and not alerting higher officials that there is despicable behavior by the lead investigator on this case, which severely is a huge issue of liability and having a clean kill prosecution against Karen Reed. So, looking at from the prosecution standpoint, they really botched this thing up from that regard, and, the district attorney was sort of left with it. But as I've seen in my career, when they do have corruption and bad stuff like that, they never punish the wrongdoer that's on the law enforcement side or the government side on the government's witness case, because they try to prop them up and act like nothing's wrong, and then they wait until after the trial, just like they did in this case with Proctor. So that's another thing that's disappointing to see, that this wasn't addressed properly. So as we found out, Investigator Proctor is suspended without pay. And if you think about it, how could he ever testify again? So if they want to retrial this case, you're going to have a guy like that. That's misconduct is so bad that the governor of Massachusetts has to say how disgusting it is and embarrassing, and doesn't meet their standards of behavior. I mean, it's really such a black eye for all the law enforcement there in Massachusetts. So for them to wait until now to address that, it's really something that shows they're not being proactive and tenacious enough. And it's also something I would say it's not a one-off kind of system where this is something that Investigator Proctor just did this just this one time in this one case. I submit to you that this is something that he's been doing his whole career. You don't talk that way about a defendant, especially a female defendant, in those crude terms. Just suddenly when a law enforcement officer is killed. So I think that poses some real issues of politics. They overcharged as well. I initially heard about this case when a district attorney, excuse me, a criminal defense attorney in Boston. I saw something on YouTube that was he was saying that this case was overcharged, and I had not looked enough about the case to make a call one way or the other. I followed some of the key nuggets, pieces of information about this case. Um, my girlfriend, who's also a lawyer, told me daily, gave me updates on what was going on in the court case, and each day there was like consensus that, well, they really haven't met the standard of proof yet. So I think that this is something that the prosecution overshot it, and if you overshot it, you can lose some credibility with the jury as well. Maybe we'll find out in the near future how long the jurors actually deliberated before they determined that it was a 0 to 12 vote in favor of not guilty. So, but in any event, it's there's some other critical pieces of information I thought that were not looking good. I mean, if you look at the expert testimony from that government expert that was trying to put together the linkage between Karen Reed's actions and the causation of death for John O'Keefe, it was really what I thought was not sophisticated testimony. The guy was sort of guessing. He talked about strange things like the crime scene spoke to him, and things of that nature. He only had a few courses here and there on accident reconstruction and whatnot, and it was really sad to see, like, the state couldn't come up with something better than that. And then you juxtapose that with the experts from the defense and how they seemed very credible. They had experience. They weren't working for the government routinely, so they had that independence level of credibility that the jury could really rely on. So I just thought that that alone right there was reasonable doubt as well. So if they don't have better evidence to link these kind of things up and have that solid framework in place, then automatically, you're going to have an issue of reasonable doubt from most jurors across the land. That's from my experience. So, like I say, this is not a matter of whether she did it or not. It's a matter of whether you can prove it beyond a reasonable doubt. So, one of the things I will clarify is the prosecutor actually want to know what really happened, what is the truth of the matter. As a defense attorney, I like to know the truth, but that's not so much of my concern if there's indicators of guilt, because I'm just trying to poke holes in the government's case. But the government has to have a locked and loaded theory on what exactly happened and have credibility with that. And so what I never saw develop here was the credibility of what they of how it actually happened. How did she actually hit him? How did he get the blunt force trauma to his head? And how did he fly 30 feet when only his arm was hit? I mean, that's sort of like defying physics and logic. And then you also got the issue of this happened with other cops around, and where were they at? And then you talk about the way the cops were being shady and hiding stuff with their phones and whatnot. So you really get the impression that the cops weren't even being on the up and up to the other investigators on the case. And and this is like all law enforcement related, and you have a law enforcement officer, an outstanding public servant like that, that's not getting a fair investigation done on his case. So in other words, this thing was botched up from the get go, and then overcharging with second-degree murder charge didn't make anything better. So as we did learn that the second charge was OWI by vehicular manslaughter. I think that one, the latest I heard, it was like maybe 4 to 8 in favor of not guilty. Um, so the 8 were voting not guilty, 4 were voting guilty. I may be corrected on that, so go ahead and make comments on that if I am. But that's what I recall from my last reading of that. So in any event, I mean, even that, if it's 4 to 8, is it really worth a retrial on that alone? I think they will probably do that. So my comment here for tonight is like murder two should be off the table. It's overcharged. They cannot prove that unless they get some other expert in there with the kind of credibility that can override the things from the defense. I just don't see that happening, and they'd have to completely unravel their previous testimony about how he flew 30 feet. One of the other things that's really odd to me is the fact that he got flung 30 feet, and then he has his cell phone underneath him in the snow. So that does not comport with from from what I would say is normal for something to miraculously fall just under his body like that. And I would presume the cell phone would go flinging off in any other direction, and that'd be the least likely place to land. So could that be an indicator that maybe he was dragged there, that he got bashed in the head and killed in the basement, and then drug out by the street there? And so that's something that that should be, I think, better addressed by the prosecution. And so I can tell you also that the amount of corruption, even within law enforcement, the amount of crimes they commit. I mean, I've seen some really outrageous, serious misconduct by government officials, and stuff gets swept under the rug. People will commit felonies to hide felonies, and you're talking about maybe millions and millions of dollars. You're talking about crimes of violence, things of that nature that try to get swept under the rug because people have political connections. So is it possible this could have been an absolute setup and plant evidence against her? Possibly. I haven't looked at the case enough detail to make that call, but I will say that I think the FBI looking into this kind of these kind of matters will have a different focus. I think that will also probably be a reason why this thing never goes to a murder two level. And so I would say, if you look at some of these other cases, look at the degree of involvement and success that the prosecution has had using the FBI in the Adelson case. Also, the other case that John and I started covering is the Karen Rogers case in Bardstown, Kentucky. That thing was dead in the water until the FBI started getting involved in that and assigning their resources to really uncover the corruption there. So there is corruption. I mean, I know of somebody personally that was was abused as a child by a law enforcement officer there in the Massachusetts region. So it's really, you can't put anything past these people. And like I said, we have to get to the bottom of it. And I hope the FBI really gets to the bottom of this, because ultimately we owe justice still to the John O'Keefe family. And so with that being said, I think we're going to have some twists and turns in here in the near future on what develops with the FBI. And I've even seen calls for Morrissey to resign based on him presenting such such a bad testimony with the investigator Proctor. So it remains to be seen. But I just wanted to let you know my viewpoint on the fact that they have not proven that charge of murder, second-degree murder beyond a reasonable doubt, and based on this all this baggage, we have a key prosecutor now excuse me, key investigator being relieved without pay, and even if they don't call him as a lead detective witness in the case in chief for the prosecution, the defense could call him and bring all that information out. So there's just a lot of botched stuff done from the prosecution, and unfortunately, that hurts the justice for the O'Keefe family. And it's also not fair to a defendant like Karen being treated and talked about that way. So it's just sort of an ugly all around mess. But we'll see what happens in the coming days. So I will cover this case in more detail. And so anyway, I do also appreciate my mods tonight for helping me out with this. I know this is very, very emotionally charged for a lot of people. A lot of people think that she's 100% guilty. Others are completely opposite. So there's sort of been like a lot of circus of protesters and supporters and vice versa going after each other. So I appreciate your professional comments on this channel. I'm trying to talk about it from a legal perspective among attorneys, like as if we were attorneys, and trying to size up the case and the way ahead. So I'm just trying to tell you why things should be done that way. Keep in mind, I made the prediction that this is a waste of time to go after the murder two charge the day before we found out what the verdict was. So just to not think that there was enough evidence there for a jury to reasonably conclude that the case had been proven beyond reasonable doubt. So, like I say, you can think she's guilty 100%, but had the reliability of that information in order to convict somebody, that's a totally different standard. So, I just wanted to bring that distinguishment out there. So, with that, if you have questions, I'll go ahead and look at. Go ahead and enter your question now. If you can put a red question mark with an emoji there, I'll start looking here at the 8:25 mark. So, okay, Lawn Lit is asking, "Do you think they should go with the bench trial next time?" I I would say on a case as serious as this, I would never have a if I was representing someone like Karen Reed, I would never go with a bench trial. Bench trials are, on a serious charge, are pretty much a guaranteed conviction. And, I even have a prosecutor I once talked to that said he took a case that he was pressed to take. He thought the guy was innocent of the felony rape charge, and this was in the military. The chain of command expected him to be prosecuted because things are very politicized there, and the defense counsel elects to go with a bench trial, judge alone, no jury, and the guy got convicted, and he was shocked that the guy got convicted, and I told him, that, well, that's pretty much par for the course. You take any serious charge, that's murder or sexual assault, that kind of stuff, the judge is gonna feel heat, and he'll have political opponents against him if he, if acquits somebody like that. So I would say never would I go on a bench trial in a serious case like this. I do sometimes, and I should say many times, I've gone to bench trials where the charges are not as serious, but if the person as a long-term, criminal convict, has a history of being in and out of jail, and if there's a lot of bad convictions that could come out at trial, a lot of times I'll go with judge alone, and I've had, a very good success doing that. So because the judge is not gonna be so, prejudiced by the criminal record, and they'll take the facts in and on themselves and not look at the whole history of crime that this defendant has for their history. So that's my comment on that here. All right, Lisa H is saying, "Do you think they'll go for a manslaughter next time and maybe with a different prosecutor?" They very well may do that. I think I heard that maybe the DA Morrissey will step down. There's some calls for that because this thing was botched, and he should have had better leadership involved in that. So I think that I think that based on, the voting of 0 to 12 for that charge, it's not gonna get better. I mean, if it was like 50-50 or better, or maybe even one under 50-50, I would say maybe that if you really think you have that tight theory and you have some reason why you maybe have some bad jurors or something, some reasonable explanation. For example, I saw someone comparing the Katie McBanwell case to and the fact that she was retried and convicted. That's a totally different matter. That was 11-1 vote to convict, and you just had one, what I call an anarchist type protester with pink or purple hair that didn't want to follow the jury instructions. So I would say that's a totally different situation. It's not an apples to apples comparison. Okay, little birdie is saying, is it odd the judge didn't ask the jury if there were charges they agreed on? They agreed she was not guilty on 2 of the 3 charges, hung on 1. Yeah, I remember looking at the verdict form, and I recall seeing, that defense counsel Jackson was making some objections, and it looked like a convoluted mess to me when I looked at it. That's something I'm very particular as a defense attorney to make sure the instructions are walking the dog, as I say, to have the jury totally understand what they're supposed to do. So the fact that the jury had 0 to 12 vote, and I'd taken this as credible because the attorneys cannot be misleading the court on what the jurors said to them, right? So they would have to take it um, as the uh, as the honest to God truth of what the jurors said to them and put it down in their motion and not mislead the court in any way. And so in doing that, assuming this is truthful, which I believe it is the case, I think it's reliable enough to believe it's accurate, then I think that this is actually something I've never heard anything so jacked up as this on jury instructions, where you don't have a hung jury, you actually have a complete uniformity of vote, but the form is so jacked up they can't even follow it. So, like I say, I blame the form and some of the verbal instructions. I remember the judge saying that upon the defense attorney saying that this doesn't make sense, it looks odd. That she basically said, "Well, that's the way we've been doing it for in Massachusetts for hundreds of years," or something like that. So I just thought that was like you can always improve the degree of clarity if something is raised you hadn't thought about ahead of time. And I mean, it could be an issue of a mistrial, and and or excuse me, something that could be reversed on further review by the appellate court. So I would hope the judge would clean this up. And I looked at the motion, and I think that they got some good points in there. The fact that the verdict form was disputed, and how they could have 0 to 12. So I do think there should be some kind of evidentiary hearing by the judge, and the judge should open it up and see if in fact it was a 0 to 12 vote of not guilty. And if that is indeed the case, and I hope they do the right thing and correct that error because of a verdict form. So it remains to be seen. A lot of judges want to kick the can to the appellate courts, not be the one to like uh, do something that's going to like unravel a case. But here we have a actual absolute mistrial, and so rather than have a mistrial in that second-degree murder charge, it would make sense if they would just look at it, and assuming it is panning out and all the jurors confirm this, then go ahead and make the right decision and look at this as like a clerical type error that's easily fixed. Good question. Thank you. Jersey Girl saying, "Do I like the way the defense attorney is representing Karen?" I think that from what I saw, I really only saw Jackson at the portions that I looked at, different sections of the trial. I thought what I liked about him is that he didn't come across too flamboyant. I think he was generally maintaining his professionalism in front of the judge and the jury. And I thought he had good tone of voice. I thought he sounded credible, and he had some good points he was raising at different times I saw him. So believe it or not, I do want to see any and all defendants have quality representation at trial. It's really not good if you can only get a conviction as a prosecutor because you got a defense attorney who's incompetent, not doing his job. So a robust knockdown dragout fight among the attorneys that's professionally done is the way it should be done. And so that's good to see. I think they put up a good defense from what I saw, and that's good for the American justice system. All right, Laura O'Gary is asking, "Do I think Judge Bev is corrupt?" No, I don't think there's corruption by the judge at all. What I was surprised about is how Massachusetts conducts their trials, where the prosecutor just says objection and doesn't have to state the reason, and then the defense attorney, um, also makes a comment, and then judges rules on it without making any like having any details of what the objection is about. And for example, if I'm a defense attorney, if the prosecutor makes an objection and it doesn't go my way, I renew the objection and give the judge more information to show why they're making a bad decision, and it's going to be an appellate issue. And I basically usually am always successful at that because I've done my homework ahead of time. I know the case law, I know the rules of evidence and whatnot. So normally a judge doesn't want to like create that kind of issue. And if they reconsider and rule my way, I think it gives me sort of a leg up because they know that I'm gonna keep circling around and raising another secondary point to reinforce my original, points raised. So I just thought it was really I don't know how they protect the record on appeal if you don't have a, full developed, robust discussion. Now granted, you can come up there to the, sidebar, and, I don't think she's prohibiting that, but not allowing standing objections and making everybody come up. It's a lot of attorneys don't want to do that, so it's just sort of weird that she's making rulings without further expansion on what the base of the protest is. But and I didn't like the fact that she said she wasn't going to change the verdict form based on the fact that she's never done that before, seen that before. So in any event, I think it directly could have led to the airing mistrial, what appears to be an airing mistrial on the first the first count. Okay, lovely Sphinx. Do you agree that Jackson's behavior is groping Karen, hugging her in public? Isn't that a conflict of interest? Okay, first of all, I know the photo you're talking about, but things are so charged in this thing with emotions. I don't know if that's a legitimate photo or not. That could have been photoshopped. Obviously, it looks improper, and attorneys are not supposed to have relationships with their clients and that kind of thing, so it looks more than just a platonic type of hug. But anyway, I don't believe that that actually is probably an accurate photo. So that's all I'm gonna say about that. Yeah, Mr. South of Boston, that's what I already talked about. Do you think the verdict form played into the jury not knowing they could have voted not guilty? Absolutely. That how else do you explain it? I mean, either the verbal instructions and or the form itself. I've never seen anything that jacked up. So on how a jury could get something so wrong. So, everyone's thinking as well, they were deadlocked on all accounts, right? No, that wasn't apparently the case. So we'll see how this plays out in court, and hopefully the judge will make the right thing happen. Chloe's mom is saying, "Do you think the judge will allow the defense to investigate the jurors?" I think there should be some investigation of the jurors. I don't think a defense counsel wants to continually interview the rest of the jurors. I think there probably will be a court hearing on it, get it on the record instead of the defense attorneys having to stick it in a motion saying this is what the juror said. So it needs to be more above board than just the defense attorneys making representations. Excuse me. Okay, thanks. Maya Rodriguez Sorensen Esquire is saying, I saw on Ashley Banfield that the pic was a deep fake, but the live did look real to me. I'm not going to lie. So, yeah, different people have other agendas out there. So, all right, Crystal Star saying, do you think the judge felt obligated to be on the side of the police? You know, I'm thinking right now when I post that question, there was one time a judge that was so pro prosecution. He actually coached the prosecutor. He would object to some of the stuff I was doing, and the process and my objection he realized was correct, so he legally had to overrule it to give a fair ruling. But then he would, like, coach the prosecutor on how to make a proper objection. I mean, that is, like, so far, not being fair and impartial, and so I did get some sense that the judge was a little bit pro-prosecution in this, but I didn't see enough of it to really come to a total conclusion that this was ongoing, and, so it's, it looked that way a little bit, but I'd like to see the whole trial before I really come to that full conclusion. Alright, moving ahead here. Denise Oliver's asking what charges were dropped. No charges have been dropped. They have, according to the district attorney, they're going forward with the same remaining charges for a retrial. But I like I say, I think after having this defense motion, this whole thing's gonna get derailed. They're not gonna go to retrial. They're gonna have, at least not yet, they're gonna have evidentiary hearings. The judge is gonna sort it out and maybe go ahead and declare, not guilty on that, second-degree murder charge. Okay, Teresa M is asking if the jury was unanimous in finding her not guilty on 2 counts, murder and leaving the scene, even though they were hung on 1 and they retry on those 2 counts, is that double jeopardy? Um, well, that's what the judge is gonna look at based on the defense motion. I think they should open this up, and if it's like an error in following the instructions, if there was unanimous vote of not guilty on the murder 2 charge and the leaving the scene of an accident, then I I would hope that they don't have a whole retrial just because, the instructions weren't properly followed. I would be totally shocked if that would happen in this case, but stranger things have happened. I mean, a lot of people like kicking the can down the road from district attorneys to judges and whatnot, so a lot of times it takes appellate attorneys to have the, sort of like the adult supervision, um, handle this matter in the proper format. Yeah, thanks, Private Eye Posse. Um, we don't it's not about hate. We're not trying to hate on anybody here. We're trying to give ultimate respect and dignity to the folks that are involved in this case, whether it be the judge, prosecutor, defense. But, there are things that I'm gonna comment on where I think is absolutely outrageous, conduct, when people are botching stuff and hurting victims' rights and hurting it's really giving a black eye to the whole system of, justice in Massachusetts. And this could have ramifications years on down the line, right? So, it's just sad to see. We really hope our justice system is better than this, but the more I think we have stuff on TV like this, the more we have, um, folks doing live streams and, videos talking about stuff going on, I think it's gonna, uh, have the public get a better visibility on the kinda stuff I'm talking about, and you realize that there is a lot of things going on that are disturbing and troubling in the justice system, so Sarah Terry is saying, "I agree that the, CW would be irrational to retry. What can they say for political cover when they make this decision?" Well, I think it's gonna come out in the wash with the, interviews of the jurors, and I think it's gonna come out that this was a mistake of, instructions in the forum, and so anyway, I hopefully I think this might be cleared up in another week or so, and they still have that second, count there, the OWI manslaughter charge, so they may just go forward on that one, and, so that remains to be seen, but I think the FBI involvement in this case could upset that as well, so I think we just gotta sit back and watch, see what happens and what actually prevails. Mon Grant's made a comment that a lot of people back blue even if they are corrupt. Well, I think you have to we all wanna hope our police isn't corrupt, right? We don't wanna be falling victim to that, where that's who we expect to show up and defend us if we call 911 or whatnot. So that's something that we don't wanna really open our minds to the fact that something out there is that incompetent or corrupt, but it's out there, and, that's one of the things that is good about defense attorneys that they shed light on that, bring some sunshine, and sunshine hopefully helps people clean up their behavior and prevents this kind of stuff from happening in the future. Alright, alright, let's see here. Bowie Vision is saying, "This is a technical question that I've been meaning to ask for a long time. Where does the protocol to ask the judge to approach a witness come from?" Well, as an attorney, you can't just walk around the courtroom and get closer to the judge without asking permission to approach. That's in every courtroom, and, we have those kind of standards of, decorum, and just shows respect for the judge, and, it's just something you learn about in law school, and it sticks with you. I think also part of the professionalism of the courtroom is such that attorneys, when questioning a witness, should always stand up when asking the witness questions, and they can obviously it's easier than an approach if they need to show them a document or something, and then they go back after they're done showing the document and getting the testimony they wanted to elicit. So, I think that sitting down, like, in states where you have to sit down, I think it's like and what always happens is a jury box, the witness is sitting higher, you're actually looking up, and from a psychological standpoint, that empowers the witness, and so what I try to do if I'm in those kind of courts is I'm looking for any reason and every reason I can to stand up, have a lot of documents I want them to have to, cross-examine them on. So I'm sort of like doing everything I can to have that I'm looking down on you because I need to try to if it's an adverse witness, I wanna be able to, extract the right kind of information, having me looking down on them. I mean, that's just a known fact that if you're looking down on somebody, that gives you a psychological edge. So I never wanna be lower than the, level of the witness. Sidebar, we say the verdict form is an absolute travesty. Like I say, I've not seen the final version of it, but it looked like it was sort of a hot mess. The very fact that this information is coming out, I think pretty much confirms it. Maya's asking what I think about the inverted video, is either unethical or incompetent by Lally. Yeah, I mean, that kind of stuff, and I think it was also the fact that they didn't disclose that right away. I think it sort of, like, was brought up by the defense, and it wasn't brought up by the prosecution on direct. If I remember, I may be incorrect on that, but I mean, any kind of manipulation of the evidence like that and whatnot, why would you do that? And it's just all that kind of stuff feeds distrust of law enforcement. And keep in mind, as I said, this is a death of a fellow law enforcement officer, and you're doing all this kind of shady, underhanded stuff. It's really just shocking and disappointing to see, right? Thank you, mods. Appreciate you guys. If you have questions, go ahead, throw the red emoji up there. A lot of good comments among yourselves. Peyton Jameson, town of Canton seems sketchy. I mean, big cities have all kinds of corruption, small towns have all kinds of corruption, good old boy system and whatnot, and, this is, all across America that way. So you gotta have some honest brokers there on the law enforcement side. It's critical to have honest brokers on law enforcement side and the prosecution side, because if you don't, a lot of miscarriage of justice can happen, and it's really sad to see that way. I mean, think about it, if you got a guilty defendant, why do you have to do anything shady? Why do you have to hide the ball on anything? Why do you have to go scorched earth? Why would you risk a, reversal on appeal all just because you're playing gotcha and playing games with people's lives? So That's really a sad thing to see. Alright, here we got, Linda Mont. You're saying the forms seem rigged. Well, if that's the way they did it all the time, I just am shocked that defense attorneys in Massachusetts allow this to go on for so many decades, 'cause it's not helping justice for anybody. Alright, Thug Nasty is saying you're indicted on a conspiracy to commit petty theft. They wouldn't have conspiracy on a petty theft, that would not be in a jurisdiction. Petty theft is like, the lowest level ticky-tacky misdemeanor. Conspiracy is always brought up on felony charges, normally not something that's, the lowest level petty theft. But assuming that's the case, either or, who's your defense attorney? Dan Rajwan or Alan Jackson, or just take a plea? I mean, I would say the, I thought Alan Jackson is, much better suited for doing felony murder type cases, and, that's all I'm gonna say. He's more the kind of style I like to see in the courtroom, and, I think he's also from Texas. I heard he's from Texas. I don't know if that's true or not. He didn't, like, really have that southern accent, but Michelle Bell saying, "Weren't there 2 attorneys on this jury? How did they not realize the implications not indicating agreement on those charges?" I don't get it. So, I don't, I'm not aware if there were 2 attorneys or not. If somebody can clarify that, that's the first I've heard of that. Yeah, you guys are talking about the photo, whether it's faked or not, so Lon, latest, have you ever seen a jury believe that the police planted evidence or otherwise were corrupt? The, yes, in terms of corruption, I would say I'm trying to think back to my, different cases. I would say incompetence is more of an angle of attack that I've used before. It's very, much so, very successfully. I'm trying to think, outright corruption is something I've had for defense, like, nothing comes to mind off the top of my head. Actually, I take that back, yeah, there was, a corrupt cop. He was, uh he was going around, and I had, like, for example, 3 different defendants come to my office within a year saying this cop beat him up when he was making the arrest, and I was thinking, "What are the odds these people have no connection to each other?" And, this guy was always in the courthouse testifying based on illegal stops anyways, making a lot of overtime pay, so I talked to the district attorney's office, and I said, "Hey, look, you guys better reel this guy in. He's got a lot of hustle to go after these people, but I think he crossed the line. Anybody that has that many challenges to the legal stops and, these reports of being beat up when they're, being, arrested is something that is looks too much smoke where there's, smoke and fire there." So, in any event, I said, "If you guys don't do this, rest assured you guys are gonna be spending city dollars defending a a federal lawsuit for a 1983 action and whatnot." So, in any event, sure enough, like, I think it was about less than 2 years later, the city got sued for some other pattern of, abuse that this guy was doing, so I don't know how that ultimately turned out, but this same guy was, um, made an illegal stop. You have to have the right probable cause to stop a vehicle, and he made up some reason, and I was able to prove the reason was a lie, and they actually got the case dismissed, before it went to trial, but I also had him in trial, where I cross-examined him on his corruption and his motives to make money, by trumping up reasons to pull people over and whatnot, so in any event that case turned out as well. So it's really difficult, I think, to go after cops that way. You gotta have the right kind of information, and so it worked out in those cases, but it's a real uphill battle, and it's not something you're always gonna easily get a jury to buy into that, so are you guys still talking about that photo? I'm surprised. Yeah, I'm not gonna talk about that anymore. Sarah Terry is saying, "What do you think about the Commonwealth having the FBI studies conclude John O'Keefe was not hit by the SUV and still trying the case, not to mention many lapses in the investigation?" Yeah, I mean, I've called more than lapses. I mean, it's outright shady stuff going on, disrespecting their fellow officers, disrespecting the justice system. So, and the fact that this is, something that was, done at the request of the FBI and that he wasn't hit. Yeah, I mean, it just goes to show that, definitely an overcharging, and, you could even make the argument there was overcharging on the second count as well, so but there was jurors that were willing to consider it, I guess, enough for them to be, found guilty. So, in any event, it is overall a black eye for, law enforcement and for justice here in Massachusetts, and, if that this is not the first time this has gone on, so these kind of things are, like, ongoing and pervasive, and it may change, from, like, city to city and be in different degrees of that, but this is not the first time this happened, so it's sad to see, but hopefully this will be the thing that's gonna force them to, clean up their act. Chloe's mom is saying, "Carl, from what you see, do you think there is a true cover-up?" I th I think that I would leave the thing as a prosecutor, as I mentioned, you wanna know the absolute truth. You don't wanna have any stone unturned. You don't wanna go with the first theory that the police are giving you. You gotta absolutely make sure that you got the right defendant in the crosshairs, of who you're going to gun down on the range, and if you got because it's law enforcement, I would ask to have the FBI brought in right away. I would not trust state police. State police and local police are too much tied together, and by failing to do that, automatically you got issues of compromise. Look at the way this lead investigator think about it, this is a murder case of a law enforcement officer in Massachusetts, and they put a guy that acts the way he did as Proctor. I mean, that's such a shocker, and, it's like I say, a travesty of injustice to everybody around. It's wrong for the citizenry, it's wrong for the victims, it's wrong, it's not properly administering justice. So, this shouldn't be some kinda game. This needs to be the most highest degree of integrity and professionalism. When you're talking about bringing down on murder charges, they're gonna spend much of the rest of their life behind bars. So, anyway, it is what it is, and they better clean it up, is all I can say. On Nancy's asking, "What is your opinion of the judge and poll the jurors?" I did not see that part of it. If they did not poll, that's something that the defense is only asked if they wanna have the jurors polled. So, if that didn't happen, yeah, that could also lead to the confusion and that mishaps. So, if the defense didn't do it, they were remiss. Yeah, Kitty's 1993 is asking, "What do you think about the judge allowing the podcaster is up on charges of witness harassment in the courtroom while they're testifying?" I I know who you're talking about, but I don't know enough about it to really, comment on that, but I think you're talking about that turtle guy, and, I'm not following that enough to really comment on it. So, yeah, I'll leave that to you, commenters. Sleuthy Goosey saying, "Do you find it concerning that a jury of what was supposed to be 12 impartial citizens can still hang even after 2 independent PhDs not hired by either side testified he wasn't hit by her car?" Well, I think that, they did have the, hung jury really just on the 2nd charge, the OWI manslaughter charge. So, yeah, I mean, it's, but some people can have the mindset she's guilty, and then the little amount of evidence they had with low credibility by the prosecution, maybe they hung their hat on that. I don't understand that part of it, but, like I say, it's something that, they're gonna have to take a serious look at, and hopefully they'll get some outsider to really take a look at this, how to handle this case, and do a full investigation before they actually retry her, and if they do, they got their the proper correction of, a botched investigation. Freebird is asking, "What do I think of the defense switching to a very small courtroom because the larger one, the one that had pretrial hearings, and didn't allow all jurors to see the full face of witnesses?" Yeah, I'm not tracking that, but if there was, any blockage of the views of face of witness, I mean, that's absolutely critical. I can't imagine a courtroom would have that as an issue, especially a bigger courtroom, and having any kind of, pillar or whatnot, whatever it was, blocking, the jurors' views of somebody in the witness box, that'd be very, very odd to see. I've never seen that before, so thanks, Copa, I appreciate your comment. Yeah, I'm just trying to say it like it is. I don't I'm not here to, I'm not here to do anything, otherwise I'm just trying to predict what I see as the outcome on these different situations, and, that's the only thing I'm trying to speak truth to you guys based on my experience. So, there's no other agenda than that. I'm just trying to make sure you guys do see, the other side of things, and, one of the things I will say is, like, what I don't like seeing and is the fact that there's a lot of folks that are talking about cases as lawyers. They're not criminal lawyers, they never set foot in a criminal courtroom, they never tried a criminal case, and they're talking about it as if they are criminal defense lawyers. So, anyway, I get that's one of my pet peeves is somebody acting like they're a criminal defense lawyer talking about it, and, and saying what should happen and will happen, all that kind of stuff, and I'm just like, it's too much to tolerate for me. So, anyway, it's one of the reasons also I was, talked to this by my brother John. So, anyway, I guess that's the upside of it. Here we have Terry asked, "What might be the breadth of the DOJ investigation? Wouldn't they I wouldn't think they'd investigate state law enforcement lightly, other cases." Yeah, I mean, they have a public corruption integrity unit that goes after things like this, so, it's probably gonna take a little while before we get the final, results from that, but, they have the right resources to get to the bottom of it, and who knows if she'll ever face another trial based on the results of that, so, I just wish they would've brought in earlier. I think they should have had their investigation concluded before they brought this case to trial because they knew it was gonna be a defense argument that there's some kinda police corruption, cover up, and the owners of the house cover up and whatnot, whatever they're accusing, saying was the real truth of the matter and that it wasn't Karen and whatnot. So, I mean, as a prosecutor, I wanna have every stone unturned so I can refute any kind of smoke screens and, whatnot the defense is putting up. So that's another reason why I would have invited the FBI in because I know automatically there's going to be allegations that this is a cover up, this is involving the police, and you just don't want to have that kind of issue. Being an ankle biter that can basically take you down and knock you out from getting the case across the finish line. Jim, you're asking, I think this case would have been prosecuted if the victim was not a member of law enforcement. I think the law enforcement aspect has a lot to do with it. I think there could be the fingers pointed at law enforcement not taking care of this the right way, and that they could have been the cause of the blunt force trauma to John O'Keefe's head. So I think that definitely politics are involved in this case, and hopefully they're going to undo some of the politics and get some sane, rational adult folks in the room and try to get the case back on track the right way, if it includes actually prosecution. But like I say, I would not talk about prosecution. If I was a prosecutor on this case until I had every stone unturned, and I made sure the FBI wasn't finding exculpatory stuff for the defense to be brought out, because that's the risk you run. You know, even if they would have gotten a conviction on Karen Reed, as the FBI is still doing their thing, and they find exculpatory information that should have been found out by the law enforcement before the trial and handed over to the defense. Well, if there's all this exculpatory information now that due diligence would have uncovered by the prosecution and it wasn't disclosed or wasn't even sought out, then it basically unravels the whole case. So you're basically starting over anyway. So I'm just big on doing the full investigation up front before you bring charges, and that way you have a clean kill all through trial and appellate levels. All right, let's see. Janie's asking about what I think about taking on the Alec Baldwin case. Yeah, actually, we just did discuss that, but it came down to the fact the guy's only facing 18 months, and it's just not serious enough charge. I would say, from my experience with weapons, you know, if anybody's handling a weapon and they're ultimately taking somebody's life by the discharge of that weapon, um, and you're the director of that movie set and whatnot, I think it's a case they'll probably win, for the prosecution, but the outlier is the fact that he's a celebrity, and if you have some people on the jury that like him, you know, that's a complete different outlier, so that's not a typical normal case, where it's so much involving a famous defendant, so that's why I declined to cover that. Alright, let's see here, I'm gonna ask a few more questions, I'm gonna go ahead and sign it off here, we're looking at, just over an hour here now. All right, we have one here from Crispy Custer's asking, "Do I think there's enough evidence to convict Karen Reed of the lesser included charges?" Well, the jury's already said on the third one there was enough, and it's sort of disputed on the second one. I mean, I would say based on the two defense experts that talked about the issue about the injuries to John was not consistent with what they would expect for a vehicle striking him, and that whole thing about him being launched 30 feet by just being hit by the arm, and I don't know, it just doesn't really make a whole lot of sense, but we'll see if they, decide to go forward with that later on down the road here. Alright, I'm gonna jump ahead here. Okay, YouTube replies asking, "Do I think the defense overplayed the corruption theory too hard in closing, let the case rest on laurels?" You know, if that's what you really believe, I think that's something to hit home on, so I'm not gonna I did not see all of it, so I'm not gonna make a speculated guess on whether they overplayed it, but I would really hit that point home if I was a defense attorney, and, because if your client didn't do it, you gotta have credibility pointing the finger at who actually did it, so if you draw on the right evidence to support that, then, you know, as long as you aren't boring the jury like Daniel Rashbaum did, then I would say it's a good thing to do. Yeah, so apparently we may have some trolls in here saying the sound is messed up, so that's a typical troll, I think, because, if there's a sound problem, John and Ben would be here in the studio, letting me know about it. So in any event, okay, Lovely Spink saying, "Do you agree with John Jackson's style of tripping every witness and trying to confuse the jury?" I did not see that when he was doing it. I've seen very limited parts of his, cross-examination, so I do not recall that being an issue, and I like I say, if it was, I didn't see it. Yeah, okay. Well, okay, yeah, so anyway, those of you I'm just talking about my predictions of the case, all right? I'm not here to talk about, um, anything about who done it, whether they actually did or not. I'm just talking about burden of proof and whether they met it and the gaps I saw. So, anyway, if some of you guys have a problem with that, I don't know what to tell you. I'm just talking about straight legal stuff, not getting wrapped up in, agendas like that. So, anyway, yes, Nancy, that's correct. So in a nutshell, Karen and I to have a retrial for murder. That's my prediction. That's what the main focus was tonight, okay? And I'll stand by that. I'll absolutely stand by that, okay? So with that, I'm gonna go ahead and sign off tonight. So thanks for your, support of, justice, and, we have not seen proper justice here in Massachusetts. Hopefully, the government will get it right, and, they'll play by the rules, and, it's gonna be very interesting how this plays out. But I will say, once again, that I don't expect the murder 2 charge to go forward for a retrial, and, they'd actually lose credibility if they do that with the next jury, if they try to go with the other charge of, OWI manslaughter. So with that said, I'm signing out, and, we will have more upcoming coverage for the Markel case, and, have a good night. Thank you.